Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order this morning. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson. Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
I'm here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
I'm here, but I'm on mute.
Chairman Yeager.
Here. We do have a quorum. Assemblywoman Hanson should be marked absent excused, please. And I know at some point Assemblyman Wheeler is going to leave us for a little bit and then come back. So if we see him leave, no, he'll be back shortly. So good morning, everybody, and welcome to day 26 of the 81st session of the Nevada Legislature. I want to welcome the members and those who might be watching, those are the members of the public who may be watching either on the legislature's website or on our very fancy YouTube channel. Before we get started with today's agenda, I'll go over just a few housekeeping rules. For anyone on the Zoom, please make sure you are muted if you're not speaking. That helps us with the audio feedback. For presenters today who may not have presented in a format like this before, if you can please make sure to state your name every time before you speak. That'll help with our committee secretaries preparing the minutes. I'll try to remind you if you forget to do that. We do expect courtesy and respect in our interactions with one another. We might not agree on policy, that's perfectly fine, but we have to be respectful to one another and to the legislative process. And then last, members on the meeting, many of us have multiple devices in front of us, iPads, multiple monitors, phones, laptops to try to participate in this meeting. So please don't see it as a sign of disrespect or inattention if members appear to be looking away. We're trying to navigate this virtual setting, and so that's likely what is happening. So with that behind us, we're going to move to our agenda. And members, as you can see on the agenda, we have one bill today and then a work session with a number of bills to consider. We're going to take the bill first and then do the work session. So at this time, I will formally open the hearing on Assembly Bill 115. And before I hand it over to our vice chair to present, I did want to let members know there was a conceptual amendment presented. I believe our vice chair sent that out by email and it should be available on Nellis. It does make some pretty substantial changes to the bill, so you want to make sure you're working off of that copy. And then I also want to welcome to the committee some of our other presenters who will be helping the vice chair present this morning. So I would like to welcome Mr. Devin Reese, Ms. Kathy Sakamura, Ms. Kim Sarat, and Mr. Andre Wade. So thank all of you for joining us this morning. We'll give you a chance to present the bill, and then I'm sure we'll have some questions. So Vice Chair Nguyen, I will hand it over to you.
Thank you. Good morning, Chair Yeager and committee members. For the record, I am Assemblywoman Rochelle Nguyen. I represent Assembly District 10 in Southern Nevada, and I am here to present Assembly Bill 115, which revises provisions to parentage. Just for a little background information on this bill and how it came about, is families often have more than two adults that actively are engaged in parental duties and responsibilities. And these families should be afforded certain legal rights and options to maintain that stability, protect their families, and ensure that the family relationship is recognized by law. Children often experience significant trauma when separated from a parent as a result of a law not recognizing the nature of such families. As the California legislature stated in 2013 when it passed similar legislation, most children have two parents, but in some cases, children have more than two parents who are the child's parent in every way. Separating a child from a parent has devastating psychological and emotional impact on the child, and the courts must be given some power to protect children from this harm. Existing law only allows for 2 adults to be formally and legally recognized as parents. This bill proposes to amend existing law and allow for additional adults to formally and legally be recognized as parents without having to terminate the right of another parent. I will tell you, and hopefully you've had an opportunity to see the conceptual amendment that I emailed out last night or had committee staff do. It's pretty major. Most of the sections in the original bill are actually being deleted, and new and or additional language is being added to the Nevada Revised Statute, Chapter 127, Adoption of Children. We'll be working off of that, so if you have any questions regarding the language of the bill, that is our starting place. As many of you know or will learn, sometimes the intent of the bill doesn't always match the language needed to implement the practice. So we will continue to work with our local experts in the courts that work in adoption area, that work in our family courts, to make sure that this language matches the spirit of the bill. Additionally, I know that several other Assembly members, including Assemblywoman Shannon Bilbray Axelrod, have indicated that they would also like to be amended as sponsors of this bill. And after the presentation of this bill, I'm hopeful that many of the other members of this committee will ask to be added to sponsorship of this as well. With your permission, Chair, I would like to share some time with Devin Reese, a Reno City Councilman, Kathy Sakamura with the National Center for Lesbian Rights, and as well as Kim Sarat, who is with the Family Law Section of the State Bar in Nevada, and really practices actually in this area of family law, and has really helped craft the language so the intent matches what we want implemented by our courts when they are using the discretion with this section, this new added section. And additionally, last but not least, we also have Andre Wade, the state director with Silver State Equality. And they will be here to provide some additional background and contextual information, as well as address any concerns with the legal and technical aspects of the bill. And with that, I will first turn this over to Reno City Councilman Devin Reese. I know that he has an appointment to get to, so I want to make sure that we hear his story because it is powerful, it is real, and it is an example of how Assembly Bill 115 will make real changes in the lives of Nevadans. And so with that, Chair, with your permission, I would like to turn it first over to Devin Reese.
Thank you so much, Vice Chair. Appreciate that. Mr. Reese, welcome back to the Assembly Judiciary Committee. I don't think this is your first time here, but it's good to see you this morning. And when you're ready, please proceed with your testimony.
Well, thank you, Devin Reese, Reno City Council member. For the record, although this morning I'm here in my personal capacity, I want to thank you, Chairman Yeager, Vice Chair Wynn, and also the Assembly members here today for taking up this important legislation. I'm humbled to support AB 115 and believe strongly that AB 115 creates a framework for all families to gain the legal recognition they deserve. And I'm just going to share with you my own personal story so you can see how this bill might impact a family like mine. For those of you who don't know, many of you I consider friends and have had the privilege of working with over the years. I married my college sweetheart, Emily, in 1997. We began our lives together. I attended law school at the University of Kansas, where our first child, Max, was born. We quickly had 2 more children, Kate and Thomas, and KJ now, and we raised them here in Reno. In 2006, our lives took a very different turn as I came out as gay to my wife. The next several years were complicated and at times very messy, but we never lost sight of how important our family was to us. I met my now husband, Felipe, and our collective lives then began to revolve, much like all of yours probably who have children, around school activities, sports, competitions of every kind, slumber parties, typical family life. In 2009, Emily and I divorced, but we remained very fierce friends and committed co-parents. Life was not easy, and not everyone got us, but I think we were very happy. In 2010, sadly, our lives were forever altered by the word no family wants to hear, which is cancer. Emily was diagnosed with stage 4 colon cancer at the age of 36. The next several years looked very much like the prior years, with us shuttling from basketball to soccer, I working as a lawyer, but all the while Emily struggled to fight a very insidious disease. Diagnosis, remission, recurrence, those became the constant themes of our household. Felipe, my husband, became our children's primary caregiver, chauffeur, tutor, mentor, friend, and dad. Unfortunately, Emily died in November of 2018. Her death left a huge hole for all of us, and we struggled. And we struggle even today to fill the gap that's left in our lives. She was radiant. Her motto was live life, love life, impact others. And before Emily died, she had several important requests, but her most important request was that Felipe adopt our children. You see, Emily always believed strongly that we were a family. We may have been a family with one mom and two dads, but we were a family. And she always felt it was in the best interest of our children that they have three parents. Unfortunately, while she was living, this was not an available legal option for us. And it created lots of headaches and heartaches during the period of time that she was fighting her cancer. Emily's wish, fortunately, was fulfilled about a year after her passing at a small gathering at the courthouse with Judge Grossman. And today, Emily's children have two dads, me and Felipe. I fundamentally believe that AB 115 is a reflection that families like ours should and absolutely must have the legal recognition and protections they deserve. And I humbly ask you to support the legislation. I believe this will allow families like ours to have the protections they so deservedly should have. And I also believe it's part of Emily's legacy of impacting others. So again, I thank you for the time to present this morning and appreciate your consideration.
Thank you so much, Mr. Reese, for sharing that personal story. And obviously, we're very sorry for your loss. I think many of us who know you followed Emily in her years-long battle. And again, just really sorry for your loss. And thank you for sharing. So, Vice Chair Wynn, I'm assuming you'd like to go in the order that you introduced speakers earlier. Is that correct? So would it be Ms. Sakamura next?
You know what? Can we start actually with Mr. Wade? I don't know if he has a couple of a brief statement that he'd like to make, but if we could go to Andre Wade next, that would be great.
Fantastic. Thank you, Vice Chair. Mr. Wade, welcome to the Assembly Judiciary Committee. It's good to see you again, and please provide your testimony when you're ready.
Yeah, thank you very much. I'll just say a couple of words. Andre Wade, ANDRE-WADE, State Director for Silver State Equality. We're a statewide LGBTQ civil rights organization here in Nevada. As the Assemblywoman mentioned in her opening statements, families look different. There's a lot of diversity in families and the way that families form. Sometimes you will have a same gender marriage where, let's say, two women, as example, reach out to their male friend to help conceive a child. And not only will that male friend be wanting to help, but will also want to have equal parenting duties and share those duties. And it'd be great for a family situation like that to have legal protections under the law by way of adoption. So according to a brief released this month by the United States Census Bureau, the American Community Survey determined that Nevada is one of the 11 states, plus the District of Columbia, with a higher percentage than the national percentage in 2019 of same-sex couples households that have children. So although the census data does not capture households where multi-parent situations occur, and because only relationships to the household was collected, we do know that same-gender couples are more likely than their opposite couple cohorts to form families through adoption. Moreover, a significant number of states are recognizing that children have more than two parents, and a number of these families are moving to Nevada and may involve children who have more than two parents and are in need of legal protections to ensure their safety and well-being. And so ultimately, we know that these provisions, once in place, will ensure that children will be safe and well cared for, because of course they're at the center of these modern families, and we want these protections to be in place. So we urge you to please support Assembly Bill 115 as we do, and thank you for allowing us to testify today.
Thank you for your testimony, Mr. Wade. We appreciate it. Vice Chair Wynn, who'd like to go to next?
You know, if we can go with Kathy Sakamura with the National Center for Lesbian Rights, I think she can kind of give a statement just on what's happening across the country in this area.
Great, thank you. Welcome to the committee, Ms. Sakamura, and please provide your testimony.
Thank you so much. Good morning. Thank you, Chair and members. I have had the opportunity to be involved with a number of states' developments of similar laws, recognizing that there are families who have more than two parents, and that some recognition and ability of these families to be protected and given the same dignity and respect as other families is vital for these children's well-being. And, you know, as Assemblymember Wynn mentioned, although most children do have two parents, some children have more than two parents, and for them, each of their parents is equally important, and that relationship that they have with each of their parents is equally important. This bill takes a step toward recognizing those families by allowing those families to seek an adoption where everyone agrees and that there are more than two parents, and that a child should be recognized as being the child of all of those people. It is similar to ways that some other states have done this, similar to how California has had this law now for many years, allowing both adoption and parentage recognition of children with more than two parents. And there's a number of other states that have laws recognizing that children can have more than two parents as well. It's also currently in the 2017 Uniform Parentage Act, which has been adopted by a number of states. And so there are a growing number of states recognizing this and taking steps to affirmatively address these families' needs. And as Andre mentioned, there are children from other states who have adoptions or other judgments recognizing that they have more than two parents, who certainly could move to Nevada or any other state. And so there likely are families not only who are living with, you know, having more than two parents in Nevada, but even families who have adoptions from other states. And it's important for this law for your law to recognize that, because this bill not only allows for adoption, but also recognizes that where anything in the law states that a child has two parents or that two parents have equal rights, that should include all parents who are legally recognized. And so that step is also important to ensure that children who are already living in Nevada have that recognition. I'm happy to answer any questions. Thank you so much.
Thank you
And
for your
Chair, with
testimony.
I'm sorry. And Chair, with your permission, if we could go last to, but definitely not least, to Kim Sarat. She is here with the Family Law Section of the State Bar of Nevada. She has worked extensively in the area of family law, and particularly with these issues. She's actually the one that brought Devin's story to light. And I think it's a very powerful story about how they attempted to recognize all three parents as parents of their children. And unfortunately, we're not able to until, there is. And I think to this day, the birth certificate and the adoption stuff only has two parents on it where they should have three. And with that, I will turn this over to Kim to kind of go through some of the language or answer any questions that you might have regarding the language or the proposed language and how that works in practice. And I think she can also give you some broad perspective on other families that this might impact in our state. So with that, I will turn it over to her.
Thank you, Vice Chair. Welcome back to the committee, Ms. Sarat. And committee, I wanted to tell you, when we heard a bill a couple days ago and we mentioned the Hague Convention, and I told you we had discussed it before, that was actually from Ms. Sarat, one of her prior bills that she presented in the Assembly Judiciary Committee. So we're already coming full circle here on week 4 of the legislature. Welcome back to the committee. It's good to see you, and please provide your testimony.
Thank you, Chair Yeager. I appreciate that. You're right. We're coming full circle. Nothing like listening to me too many years in a row, but Kimberly Sarat, Surratt, To clear up something, yes, I serve on the Family Law Executive Council for the State Bar of Nevada. I am not speaking on behalf of the section. We have massive amounts of procedures in order to do so. We have to put votes out. We have not done that with this bill with the State Bar. However, I'm an unpaid lobbyist. Oh, it's okay. I just got to make sure I'm real clear on the record. I am an unpaid lobbyist with the Nevada Justice Association, and the Nevada Justice Association is behind this bill, and I can speak on behalf of that domestic committee. As stated before, we gutted all the language. So to give some clarification on that, we didn't hit the mark on the first draft of this bill on what the intent was. It was not bad language. It was decent language. It was scattered throughout all the chapters, but it isn't language that we were aiming for. We weren't aiming for, in a custody case, to have other family members be able to access parentage without going through an actual parentage procedure. We want them to become parents either through adoption, or if we do have a reproductive chapter too, which is a different conversation, but that chapter already allows for more than two parents by the nature of its own language. So the intent was to go straight into the adoption chapter and make the changes needed to say that we weren't limited to just two parents. The key phrase, the key sentence that needed to be changed is in NRS 127.030, section 1, where the first sentence states, the old language was any adult person, singular, or any two persons married to each other may petition the district court of any county of the state for leave to adopt a child. That's the key sentence that needed to be changed and modified in order to allow attorneys like myself who do family law to be able to access the courts and give the courts the flexibility to allow more than two parents. We added an additional sentence at the end of that section that does say one or more adults may petition to adopt a child, to make it extremely clear what the goal of this bill is. The last part of that is that each prospective adopting adult and each legal parent seeking to retain their parental rights must be joined as a petitioner. That may seem benign, but in my world as a family law attorney, that is not a benign sentence. That is incredibly important. Through my practice as an adoption attorney, I actually just a month ago received a call from another attorney saying, hey, so if I have a step parent who's adopting, do I have to make the parent who is keeping their parental rights a petitioner in the case? And I said, it's interesting, that chapter is silent on that. I've always done it in practice. It's something that's silent that attorneys who do a lot of this work know about. And we do it because obviously the parent who is retaining their rights needs to give consent and needs to be part of the case. And so what we're saying by this, what is really critical in this, is that the existing legal parents of the child need to consent. So for any concerns that may be out there that somebody can insert themselves as a parent through these changes, they can't. They can't force themselves on two parents. So a grandparent, for example, can't force themselves in and say, I'm going to adopt and I'm going to make you allow me to adopt. They have to consent. The legal parents have to consent. There's numerous other changes in the conceptual amendment, and really all of the additional changes go along the lines of making sure that consent is available, making sure the language, from singular to plural, to make sure that we just cleaned up that it's the legal parents consenting to add an additional parent. Or it could be that three parents are coming in to adopt. Different scenarios. So as the Assemblywoman alluded to, I can give you lots of examples. I choke up when I think about City Councilman Reese, because Emily was a good friend of mine. We had lots of talks about this because my son has a stepmother who I adore, who is the most amazing human being on the planet. And would I like her to be a mother? Yes, if I pass away. If I pass away, do I want to be removed from the birth certificate of my son? No. I want to live on into eternity as his mother. And just because a third parent is added into the future, I shouldn't be removed from the birth certificate. I should remain as his mother. and others who have legal responsibility or want to take over legal responsibility for my son should be added in, but not have me removed as a parent. This bill has a very critical element to that. It allows me to live into eternity as his mother. I have lots of scenarios where both birth parents passed away and both sets of grandparents want to adopt. They're elderly, they can't handle a child 100% on their own in their house, but they're all going to jump in and they're all going to parent this child together. When one set of grandparents adopts, they sever the legal relationship with the other set of grandparents. That's also something that should not happen in life. Just because their parents passed away doesn't mean that you should sever the inheritance rights, sever that link. And it's important that if the original legal parents stayed on that birth certificate, there wouldn't be a severance of that. The inheritance rights would stay intact, and the child would continue to be a parent or be a child of both sides of the family. I'm getting choked up. My goodness, I didn't think it would be this bad for me, but this bill is really important to me, obviously. One last thing that I want to throw in there is that we did talk to Vital Records. We had a very good meeting with them about the birth certificates, about the functionality of being able to do this. Also to make sure we weren't going to have a fiscal note. They're not concerned. They obviously have not put a fiscal note on here, and it is feasible. They are able to do this for us. They have the means. They were happy to do it. They were excited to do it, and we are not concerned in that area. We had some phone calls with Child Protective Services, some of the district attorneys, and the concerns all came from the original language. Once I explained the intent with the amendment, those concerns disappeared. However, with the new language, because it is a complete gut, I will field any questions, and I'm not going to presume I got it right on my first draw through this, because I had to draft it from scratch to replace the original language. So knowing that, Chair Yeager, we will entertain amendments. We will entertain the fact that maybe I got it wrong in the drafting process. Thank you.
Thank you for your testimony. Appreciate it. And thank you to all of you who helped present the bill this morning. There are some questions. I have a couple I want to ask while they're on my mind. I don't practice in this area of law, and obviously, Ms. Sarat, you are the expert. And so something you said in your testimony sort of struck me because I didn't realize this, and I want to confirm that I got it right. So when you have a scenario where the birth parents pass away and grandparents adopt, are you saying that they actually go back and change the birth certificate to take the original parents off of the certificate, and then they put the new adopted parents on? Is that how it works now?
Yes, unfortunately, the way it works right now, I'm sorry, Kimberly Sarat for the record. Yes, Chairman Yeager, that is the way it works. Right now, it's a clear cut. When somebody adopts, the child's prior parents and legal circumstances, inheritance rights are severed completely, and the new individuals adopt. Now, you do not have to go amend the birth certificate, and I believe we probably don't have City Councilman Reese on the phone anymore, but that was the solution there, is you can get a court order for the adoption and just not amend the birth certificate. You have court orders saying you have legal rights, and you can, but that birth certificate, by not amending it, it's just, you're doing it out of respect. But, can you go out in the world and function without a birth certificate? Yeah, you can get away with using a court order as much as possible, but we all know that when you have a birth certificate and your name's listed on it, life's a little bit easier for you to function in the world.
And City Councilman Reese is still on the call if he has any statements on that.
Yes, Devin Reese for the record. Thank you, Mr. Chair, for your question. It was absolutely that way. There was, my children, of course, are Emily's children and our children. And so we did not change the birth certificate in that way. And so it is a strange wrinkle in Nevada law that could be corrected with the bill. Great, thank you. And then the other question I have, probably for Ms. Sarat as well.
You obviously indicated that, the parents, legal parents have to consent, that someone can't just sort of force their way into this. And again, I've never participated in one of these proceedings, but I've heard that, adoptions can take quite a long amount of time. And I just wondered if you could give the committee just sort of a sense of if there is a typical, I know every case is different, but generally, how long does this process take? How much is a judge involved? How much does it matter about a parent? If a parent doesn't consent, is the adoption just not going to happen, or does judge have flexibility there? If you could talk a little bit about that process, please.
Yes, Chairman Yeager, Kim Sarat for the record. To be clear, so we've got two different types of adoptions that can occur under this chapter. We've got the step-parent adoptions, which is really just adding in parents or a parent, or we've got a adoption per se, perhaps out of the system, where the child's parents have been terminated and you're adopting out of the system. This bill and the language, the intent of it is that if we're in the system part of it, where we're adopting out of the system, that you can have 3 people adopt out of the system if the court finds that that's in that child's best interest. Do you have to have parents consenting? No, you don't, because they'll be terminated. However, you'll have to have the court consent, right? So out of the system where it's not an add-in of parents in a step-parent sense, those adoptions do take a greater amount of time. They include a home study, an inspection and report from the social services unit that's in that area, reporting to the court. The termination takes the longest part of the adoption process, and that's what usually when people weigh in about how bad the adoption process is, it's because trying to terminate the parental rights of the abusive or neglectful parents takes the most amount of time. This bill won't change the length on that because that's a whole different chapter and a whole different issue. On the actual adoption itself, once we file an adoption, we can get a hearing within a reasonable amount of time, usually we've got to wait at least 30 days, but usually 30 to 90 days out, we can get a hearing with the court. That's that side of it. If we talk about the step-parent part of it, the step-parent adoption process, there is language in the adoption chapter that allows for when one of the petitioners is within the 3rd degree of consanguinity of the child, then we can waive the report, waive the home study, and it's a shortcut process for step-parent adoptions. So if we're adding in a 3rd or 4th parent, but you've got a consenting parent that's keeping their parental rights, it's a shortcut process and we don't have to do the home study part of it and we don't have to go through that process. Pursuant to the adoption chapter right now, it still requires a hearing in front of the court. There has been a lot of complaints over the years by step-parents and parents about having to go to a hearing for those proceedings. When you've got a consenting parent, if everybody's consenting, it's an easy process. The intent of this bill was to add in additional parents. I did not address the issue of the hearings within this, but that is an amendment that I would say if you were to canvass the public, they would say probably get rid of the hearing requirement because that takes time. It takes a lot more money from attorneys having to appear on their behalf for something they're all consenting to, and there's really no reason for the court to overturn it. We show up for all of 5 to 15 minutes, and the only reason it would take 15 minutes is maybe pictures and glad handing with the judge to do those hearings, and they pay attorneys a lot of money to do that. And I know step parents wouldn't mind, or third parents, they don't have to be step parents under this bill, but just other parents with a consenting parent would not mind getting rid of the hearing requirement.
Thank you. And just a quick follow-up on that. I'm assuming that you've never seen a scenario where you have parents all consenting, and then you go in front of the judge and the judge says no. It sounds like it's pretty much a go if everyone's consenting. Is that your experience?
That's correct. I have not. It's always in the cases where somebody's trying to adopt a child out of the system and they don't pass the home study. Maybe they have a criminal record or something else is going on there, but I have not in these And this Kim Sarat for the record. Sorry, Chair Yeager.
No, it's okay. We're all getting used to
whole
this.
Zoom thing.
Yeah, we're all getting used to this again. And, before I hand it over for other questions, I did want to make sure, I know we have some newer members on the committee, that you understand the difference there. There's two types of adoptions, and the one that we're not talking about today is a scenario where you have a child in basically the child welfare system, and the parental rights are terminated for some reason because of abuse and neglect. This bill doesn't have anything to do with that process. That'll sort of continue the way it is. This bill has to do with consenting parents whose rights are not being terminated, so they're going to remain on as parents. So hopefully that provides some clarification. The termination of parental rights procedure may be something we discuss in later bills. Occasionally we get bills in this committee touching on that, and it's a lot more complicated process. Okay, so I've got questions so far, and I'll just kind of go with the order I have at the moment. So we'll start with Assemblymember Miller, and then Assemblywoman Cohen, Summers Armstrong, and Krasner. So Assemblymember Miller, please ask your question.
Yes, thank you all so much for the presentation and for bringing the bill forward. I think it's important, as someone who is a product of having amazing step parents in my life. I think that, that speaks to me personally. With that in mind, I do have a question as to a question of just clarity for myself, and that is when step parents have to go through the adoption process to be covered by this law, correct?
Chair Yeager, would you like me to respond?
Yes, please. And you can go directly to the member if you can just remember to state your name, please.
Okay, thank you. Kimberly Sarat for the record. Assemblyman Miller, yes, step parents have to go through the adoption process. That was kind of that last comment, which is it wouldn't hurt to eliminate the hearings on that because it's kind of ridiculous and silly at that point when everybody's consenting.
Got you. Thank you. And then just my next question is directly about like divorce. So even in my family, I grew up in a family where my parents had multiple divorces, even though I love my step parents and we still get along and love each other to this day. I hope my mother does not kill me or my father does not kill me for sharing this information. But I am curious to know after say the divorce or the separation of a family, which is a very real thing that we know happens every day. How does the law then affect? Do they have to go through custody hearings and things like that? And what do we foresee the impact of that being?
Kimberly Sarat for the record. Assemblyman Miller, yes. So once you become a parent, once you adopt, you're a parent. That's all there is to it. So there is the complexity of within a divorce matter, additional custody proceedings to deal with the step parents and visitation time with the step parents and how custody will be delved out. That is the concern for if you talk to a regular divorce attorney, they're going to say, oh my goodness, more work. But the reality is we have that work anyways, because we have step parents trying to use the third-party visitation chapter in order to get that time with a child that they literally raised from an infant up to 16 years old, and now they're getting cut off because they had no parental rights. This is a major step. I mean, parents will need to stop and think about the adoption process because it makes you a full parent with all the rights and responsibilities. So responsibilities kind of being the key word, child support and everything else. You raise this child, you want to become a parent, you're going to adopt, you're going to have everything that comes with it.
Thank you.
Chair Yeager, would it be helpful for me to give a little context about how this has played out in other states that have had these laws for many years?
Yes, please, Ms. Sakamura, please go ahead.
Thank you so much. Kathy Sakimura from the National Center for Lesbian Rights. So there are, as I mentioned, a number of states, not only California, that have similar laws, also Washington State, Vermont, Maine has had this law for a number of years. And in fact, Louisiana has had a law that allows 3 parents in some situations for decades. And so we do know how this plays out in other states, which is that there are relatively few families who fall into these categories. And as Kim Sarat mentioned, everyone is a parent who has full rights to custody and full obligation to provide child support. But it is in many ways not more complicated than between 2 parents, where you have other people who have close relationships with the child seeking to have visitation in some way anyway. And that courts have looked at the situation. Sometimes they may decide that there are 2 parents should have joint, essentially share most of the primary custody, and another parent doesn't have as much of a role and should have more limited visitation. It doesn't mean that a child is moving to a different house every 2 days and there's 3 or 4 houses in most situations. Typically in families with multiple parents, there are some parents who don't play as much of a role in the day-to-day care of the child, and it is not a difficult question. And the cases that actually go to trial or some sort of dispute in custody are always a minority of cases. It's about 15% of cases is the sort of rule of thumb that people say are highly contested. And that seems to play out similarly in cases with multiple parents.
Thank you for that clarification. Appreciate it. We'll go next to Assemblywoman Cohen.
Thank you, Chair, and thank you all for the presentation, and thank you especially, Councilman Reese, for sharing your family story. My question is about service requirements with siblings, because as we know with families, we all often have siblings with different parents or not the same combination of parents. So can you please address if we're going to have the requirements of notice to have siblings, or a sibling who maybe is already an adult, so isn't part of the concern about adoption?
Yes, thank you, Assemblywoman Cohen. This is Kim Sarat for the record. You know, on the adoption, when you have a step-parent adoption, or even an adoption after termination is taken care of, we have no service requirements within this chapter that affect the sibling part of it. The sibling service requirements are all within the termination of parental rights chapter and all regarding that side of those cases. None of that will be changed. The priorities of social services for placement of children with consideration of visitation with siblings will all still be intact. Remember, we're not in this chapter terminating a parent's rights for a step-parent adoption for additional parents to be added in. If you have 3 people wanting to adopt out of the system through that adoption process, all of that would have been taken care of through the termination with notice to all the relatives and siblings before the termination takes place.
Okay, thank you. And Chair, can I have a second question?
Please go ahead.
Okay, thank you. Also, in NRS 127.040 with guardians, I want to make sure I'm understanding with the consent for the guardians, we're just talking about a permanent guardian, not a temporary guardian? Is there, are we differentiating?
Assemblywoman Cohen, Kim Sarat for the record. We are not differentiating. So it would be a temporary or a permanent guardian. The point here is that they're the ones that have, they need to be participating in that process. So instead of notice, you're getting consent. So it kind of answers your last question, which is anybody else that is raising that child at that moment, they need to consent if they have that guardianship over the child. Because then at that point, if you have a guardian over the child, the parents may have already been terminated, or there's something else going on there.
Okay, but if it's a temporary guardian can't give, I just want to be clear, a temporary guardian can't give consent that takes the place of the parent's consent.
let me unmute myself, geez. Kim Sarat for the record, Assemblywoman Cohen. No, it does not take the place. It has to be, if there are legal parents, they need to give consent. So it may be a language issue between section A and B with the or, and it may be you and I need to think about the or on that and see if we need to be and. If there's a legal guardian, they need to consent. That might be, or I'm thinking on the cusp right here about the language, but I can take a look at that, the or between section A and B under 127.040 and figure out the right wording there to make sure we're hitting the mark with your question.
Okay, thank you. I appreciate that. And Vice Chair, I'd very much like to also sign on as a co-sponsor.
Thank you. I will add you to the list as well.
All right, let's go next to Assemblywoman Summers Armstrong.
Thank you, Chair Yeager, and thank you all for the presentation. I actually think my question has been answered, but I'll ask it just to make sure that I'm really clear. Like Assemblyman Miller, I had a mixed family, divorced from my first husband, and I have 2 sons, and we ended up co-parenting. There were 3 dads, 2 dads and mom, 2 dads and mom. And I often worried about what would have happened if something happened to me. So in this instance, if I'm understanding correctly, my current husband would have had the ability with this law as it is written to adopt our sons so that all 3 sons are cohesive without my ex-husband giving up his parental rights. Am I hearing that correctly?
Yes, Assemblywoman Summers Armstrong, this is Kim Sarat for the record. Yes, with parental consent. He couldn't do it on his own. You and your ex would have to consent.
Okay, thank you very much. That is clear. Thank you.
Thank you. We'll go next to Assemblywoman Krasner.
Thank you, Chair. Can you hear me? Okay, good. So I have a couple of questions because I'm having difficulty grasping this. I understand there's the 2 different types of adoption, the natural parents and then working out of the system. So my first question, if I may, the natural parents, both original parents must consent to allow a 3rd person to be known as a parent. Is that correct?
Assemblywoman Krasner, Kim Sarat for the record. Yes, that is correct, so long as those parents are alive.
Okay, so now working out of this system, you said 3 people can be known as parents. How about if 2 females, 2 males, and then they want the grandparents, another female, male. There's 6 of them because they think that would work best. Can they all be the natural parents or known as the legal parents for the child that they adopt out of the system, number 1? And number 2, how does that work with, like, one of them's an anti-vaxxer, one of them wants the kid to have vaccines? Who does the pediatrician go to get the legal permission? They get divorced. Who's paying child support to who?
Assemblywoman Krasner, this is Kim Sarat for the record. Let me break that into a couple of pieces so I can answer your question. So the first part is about adopting out of the system. And if you had, just for an example, 6 people that want to adopt a child out of the system, you have to remember that through this system, they still have to get consent of the social workers or who have custody over that child. It has to be in that child's best interest. They're not going to grant consent for adoption of 6 people that don't get along, aren't on the same page. The most likely use of this chapter is going to be step parents. Could you have 3 people who go into the court and say, we want to adopt this child, and all 3 are not relatives of the child? You could under this bill, but the social workers still have to consent that it's in the best interest of the child. Now, when I talk about step parents being able to do the shortcut process for adoption where maybe you have two women and two men that want to all be parents of a child. Somebody's got to be, for the shortcut process, they have to be within the 3rd degree of consanguinity. We have a nice fancy chart in Nevada that shows you the degrees of consanguinity. And off the top of my head, I can never tell anybody exactly where that ends, but it's kind of at the grandparent, aunt, uncle level. When you get past that, if they're cousins, you have to go through the full bore process of the home study and the inspection and the report and the consent of the court. So the court decides it's not in the child's best interest because they're all over the place and there's too many of them and it's not going to make sense for the child. They're not going to consent to it. It's not going to be approved. It probably won't even make it through social services saying they're going to assign them, the child, to those parents as potential adoptive parents. On the complexity of child support and custody, yeah, you're probably going to have that, but we also have the complexity of third-party visitation actions that are separate from the divorce. This would, minimize that and at least get to the heart of the fact that when they did this adoption and more than two parents decided there should be more than two parents, they decide that was already in the best interest of that child, and the court doesn't have to make that analysis. They're jumping to the heart of where should this child be, who should be paying child support, and who should not.
Follow-up, Chair. But if you can have 3 people adopting out of the system, why not 4? What would be the rationale and not? They all get along really well. They think they're the best person in the world, but of course things change. 10 years later, they hate each other and then there's a divorce or 2 divorces. Is the kid now going to 4 different houses, 1 week here, 1 week there, 1 week here, 1 week there? I can see there might be a lot of unintended consequences.
Assemblywoman Krasner, I think your questions are getting a little far down the line. I'm happy to have Ms. Sarat answer that one, but what might happen in a later proceeding when parents don't get along? We have those issues now with current family law. That's why we have judges and social workers and child advocates. So I want to try to stick to the substance of the bill rather than what might happen down the road. But I'll let Ms. Sarat try to answer that question to the extent she can, because every situation I think is going to be really different depending on the circumstances. But go ahead, Ms. Sarat.
Thank you, Chair Yeager. Kim Sarat for the record. It's real easy to try to throw out those hypotheticals. And when we look across the nation, and I know Ms. Sakamura can also testify to this, we just haven't seen the problems in the other states that allow multi-parent adoptions. They don't occur. They don't get as complex as people like to abstractly say they're going to be. I'll tell you, family law is complex already in and of itself, and getting to what is the best interest of the child as to who they should spend time with takes a huge chunk of litigation and time that we're skipping with this process because they've already agreed that that's what's in the child's best interest, is seeing those people.
Ms. Sakamura, did you want to add anything to that based on, I think you touched on it earlier, but just based on your experience in other states?
Absolutely. Thank you so much, Kathy Sakimura, for the record. Yes, we really haven't seen in other states and these fears about lots and lots of people becoming parents through this process. There certainly are 3-parent families, of course, and there's 4-parent families that come about. Often 4-parent families come about where you have a gay male couple and a lesbian couple who have children together. They, have always functioned as parents together, and they don't just want one of each of their couple to be parents. And those are the most common 4-parent families that we see, and they usually have a long history of parenting together. Certainly, some of them break up, and courts do have to deal with that. The way that it works is that courts don't have to, if the parents are not going to be able to cooperate after the breakup, give all parents equal legal decision making. And they don't have to give all parents equal custody time. And courts look at, what is the historical role of each person in parenting that child and making decisions, and what is the parent's ability to make those decisions together even after separating. And that is a role that courts already play in 2-parent family cases, and it plays out similarly as far as we've seen in multi-parent families. And in many ways, from what we've seen in the multi-parent families that have broken broken up is that they have more experience with cooperation and dealing with conflict because they have already necessarily had to deal with multiple people making a decision together. And that we don't really see these super high conflict inability to cooperate cases very often with multi-parent families because they've already had to navigate those hard questions with people that they're not even in a relationship with. So I hope that's helpful. But just that, there's actually been now many years of these laws in a number of states, including California, of course, which has a very large population and has had these laws for about, I think it's 9 years now. And so we have seen a number of families in these situations, a number of families who've become parents and then later separated. And it hasn't really played out in the ways that there were sort of initial fears of the complexity. And then the positive side is that for child support purposes, there's more people who are available to support that child to avoid going on public assistance. In a situation where one parent becomes incapacitated or incarcerated or otherwise unable to care for the child, you have more opportunities for that child to stay with a parent rather than entering the child welfare system. Thank you.
Thank you. I appreciate that. And Assemblywoman Krasner, if you have additional questions along those lines, I would just encourage you to reach out after the hearing, but I want to make sure we have enough time to get through other questions and our work session. So do we have other questions from members? If you could show me by raising your hand in front of your monitor, that would be helpful. And let me check the chat as well. I don't see any there. Okay, I think we don't have any other questions at this time. So to our presenters, I want to thank you for presenting. We'll give you a chance to do some concluding remarks once we get through the testimony on the bill. So just sit tight for the time being. And at this time, I'll go to testimony in support of Assembly Bill 115. I don't think we have anyone else on the Zoom with us in support. BPS, could we check the phone lines to see if there's anybody there who'd like to offer testimony in support?
Good morning. Thank you, Chair. For callers wishing to testify in support, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 377. Caller with the last 3 digits of 377, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. My name is Deshaun Jackson, DASHUN JACKSON. I currently serve as the Director of Children's Safety and Welfare Policy with the Children's Advocacy Alliance, and we stand in support of AB 115, the third parent adoption legislation. We believe this bill would aid in preventing trauma caused by the loss of a parental figure. It would assist in ensuring a relationship is maintained. Thank you so much.
Thank you for your testimony, Mr. Jackson. BPS, do we have anybody else on the line in support?
Yes. Caller with the last 3 digits of 695. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Mr. Chair. My name is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada. I will be quick because I don't want to cry, and I've pledged that I will not cry on the record this session. But we support this legislation because we have been at the forefront of the battle to defend rights of LGBTQ parents, throughout this country for decades. I'm incredibly pleased that my dear friend, Councilmember Reese, is presenting this bill today. I knew Emily incredibly well. She knew that the Reeses and their pieces, that's how she referred to her family, were in great hands with Mr. Cisneros. Their family is a beautiful example of the support and compassion that we foster when we dismantle discriminatory laws and embrace inclusion. So yes, live life, love life, impact others, we can certainly impact others with this legislation. And for these reasons, we support this bill. Thank you.
Thank you, Ms. Wellborn. Appreciate your testimony. BPS, anybody else in support?
For callers wishing to testify in support of Assembly Bill 115, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 292. Caller with the last 3 digits of 292, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. This is Melanie Scheibel, MELANIESCHEIBLE. I think everybody on this call, as I'm a member of the Nevada State Senate. I represent District 9 in the southwest part of Las Vegas. And I just wanted to call in and voice my support for this bill. I think it's really important that we start to recognize that there are different forms of families besides just 2 parents and who appear on a birth certificate. And it's important that everybody have access to that kind of legal recognition. And I'm very proud to be a co-sponsor of this bill and encourage you all to support it. Thank you.
Thank you for your testimony. It's always good to hear my senator calling in on these meetings, and I'm sure I'll be returning the favor in Senate Judiciary in the very near future. BPS, do we have anyone else in support?
Any further callers wishing to testify in support of Assembly Bill 115, please press star 9 now to take your place in the queue. And Chair, there are no further callers to testify in support.
Thank you, BPS. I will close testimony in support. I will now open testimony in opposition to Assembly Bill 115. We don't have anyone on the Zoom with us in opposition. BPS, could we check the phone lines to see if there's anybody there who would like to testify in opposition?
Yes, thank you, Chair. For callers wishing to testify in opposition of Assembly Bill 115, please press star 9 now to take your place in the queue. Callers wishing to provide testimony in opposition for Assembly Bill 115, please press star 9 now to take your place in the queue. And Chair, there are no callers wishing to testify in opposition at this time.
Thank you, BPS. I will close opposition testimony. I'll now open neutral testimony. We don't have anyone on the Zoom in neutral. BPS, could we check the phones to see if there's somebody there who would like to testify in neutral on Assembly Bill 115?
Thank you. For callers wishing to testify in neutral of Assembly Bill 115, please press star 9 now to take your place in the queue. Callers wishing to testify in neutral for Assembly Bill 115, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS. I will close neutral testimony. And now would be the time for any closing remarks. So Assemblywoman Vice Chair Wynn, I'll hand it over to you first. And I think we still have a few others who help present. So if they would like to make comments after you, that would be appropriate too.
Thank you, Chair Yeager. Assemblywoman Rochelle Wynn for the record. Thank you for giving me the opportunity. And I really want to thank City Councilman Devin Reese for sharing his personal story. It had a significant impact when I heard it. It motivated me to, move forward with Assembly Bill 115. And I'm so glad that he was willing to and able to share that. I think it highlights what this bill would hope to accomplish if passed. So I would strongly encourage your support in supporting Assembly Bill 115. And with that, I will turn it over to, I think, Ms. Sarat first, if that's okay.
Thank you, Vice Chair. Ms. Sarat, any concluding remarks?
Thank you, Chair Yeager. Kim Sarat for the record. Yes, I know that we may not have gotten all the questions out today based on us gutting and replacing the language. As I stated earlier in my testimony, I'm here for any questions and adjustments in language if needed. And I just encourage you to pass this bill. Thank you.
Thank you so much. Vice Chair, would you like anyone else to give remarks?
You know what? If we can go to Kathy Sakamoro, I know that it is, I appreciate that she's a working mom because I think I heard a toddler in the background, and I'm sure all the legislative mamas on here can also appreciate the circumstances we're working in. So if she'd like to say something, I turn it over to her.
Thank you so much. Yes, my young children are running in the hallway at the moment. Thank you so much. Kathy Sakimura for the record. We stand, of course, in strong support of this bill. I think recognizing that families come in so many different forms, and that what is most important for children is that the actual realities of their family lives be recognized and supported by the state, and that we don't unnecessarily separate from children from their parents when circumstances change, and ensure that children have that ability to maintain the relationship with all of their parents when something happens or a crisis arises. So we thank you so much, and we urge your support.
And finally, Chair, if it's okay, I'd like to finish off with Andre Wade from the State Director from Silver State Equality. I know that Silver State Equality is fairly new to Nevada, and they've made just an amazing big splash in bringing this needed change to our existing laws to my attention. I know that there are lots of letters potentially in support or will be forthcoming, so I would encourage our members to also check on Nellis any of the support documentation that has been provided in addition to the testimony you heard today. And with that, I will leave this to Andre Wade.
Thank you, Chair Yeager and Co-Chair Nguyen and the committee and my co-presenters. I won't take up too much time and just echo everything that everyone said, but really appreciate folks hearing about the diversity of families and recognizing that this isn't just an LGBT issue, it's a family issue, it's a children's issue, and that we hope that Nevada will continue to lead the charge of being a state that is welcoming and inclusive no matter what a family looks like. So Silver State Equality, we are in full support, and thank everyone for their time, and thank you Vice Chair Nguyen for taking on this bill, and Kathy and Kim. It's been a pleasure working on this for Nevadans.
Thank you so much, Mr. Wade. Thank you to all of you who spent a little bit of time with us on Friday morning presenting this bill. We appreciate it, and we hope you have a great rest of the day. So with that, I'm going to close the hearing on Assembly Bill 115. Is anybody ready for a work session? I see excitement out there. So let's go to our next agenda item, which is our work session. I'll now open up our work session for members of the public and committee members. The supporting documentation for the work session is uploaded on Nellis. Members, I think you would have gotten it by email as well. Just for clarification, we originally had Assembly Bill 59 on the work session. We did end up revising the agenda, so we are not going to consider Assembly Bill 59, which is the T21 tobacco bill. There's still some work to be done on that one, so look for that on a future work session document. But at this time, we'll open the work session, and we'll start with Assembly Bill 17, and I will hand it over to Ms. Thornton to tell us about Assembly Bill 17, and then we'll proceed from there.
Thank you, Chair Yeager. For the record, Diane Thornton, Research Division, Legislative Council Bureau. As nonpartisan staff, I'm not here to advocate for issues, but to assist members with policy issues brought forward to this committee. Our first bill on work session today is Assembly Bill 17, sponsored by the Assembly Committee on Judiciary on behalf of the Division of Parole and Probation and heard in committee on February 10th. This bill eliminates the distinction between an honorable discharge and a dishonorable discharge from parole or probation. There's one amendment for this bill, sponsored by Victoria Gonzalez, Executive Director, Department of Sentencing Policy. The amendment revises the reporting requirements that the Division of Parole and Probation is required to submit to the Nevada Sentencing Commission. And the amendment is on the following page. Thank you, Mr. Chair.
Thank you, Ms. Thornton. Committee members, you'll recall this is the first bill we heard in committee, which, to be honest, seems like a year ago at this point. But before we take a motion, are there any questions about Assembly Bill 17 as detailed in the work session document with the amendment? And just as a reminder, I'll give you a chance to make any comments you might have before we vote, but now would be the time for questions if anyone is confused about what is in the work session document. Okay, I don't see questions, so what I'm going to do is I'm going to ask for a motion to amend and do pass, and I think probably just a show of hand by somebody who'd be willing to do that. So I have a motion. Vice Chair, why don't we go to you? You can say it on the record, please.
I would move and do pass Assembly Bill 17.
Was that a motion to amend and do pass?
That's correct. Amend and do pass Assembly Bill 17.
Great, thank you. And who would like to provide a second on that? I saw Assemblywoman Gonzalez first, so please go ahead.
I second.
Okay, we have a motion from Vice Chair Wynn, a second from Assemblywoman Gonzalez. Are there any comments on the motion before we vote? Okay, I don't see comments. In committee, what we're going to do is we'll take a roll call vote on these just because we're not in the same room and it's a little bit hard to do a voice vote. So, Madam Secretary, could you please take a roll call vote on Assembly Bill 17?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hardy.
No.
Assemblywoman Kasama.
Sorry, no.
Assemblywoman Krasner.
No.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
No.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
No.
Chairman Yeager.
Yes. So I think the final tally there was 9 in support, 5 opposed, and we have 1 absent excuse. So that motion does pass, and I'll assign the floor statement on Assembly Bill 17 to Assemblywoman Gonzalez. Okay, so let's go next to Assembly Bill 23. Ms. Thornton, take it away, please.
Thank you, Chairman. Assembly Bill 23 was sponsored by this committee on behalf of the Division of Public and Behavioral Health and heard in this committee on February 17th. This bill revises the procedure for the commitment of certain criminal defendants who were found to be incompetent by the court. There is 1 proposed amendment to this measure. This amendment was proposed by Dr. Neighbors from DPH, Kendra Birchie from Washoe Public Defender's Office, and John Pirro, Clark County Public Defender's Office. The amendment revises the time allowed for DPBH to complete the comprehensive risk assessment from a reasonable time within 40 calendar days after the receipt of the request. Additionally, the court may grant DPBH a continuance to complete the comprehensive risk assessment. Thank you, Mr. Chair.
Thank you, Ms. Thornton. And before I open it up for questions, committee, you may remember there was the real testimony on this was how many days the division would have to do this report. And it looks like, thankfully, they reached an agreement. So what you see in the amendment is 40 calendar days, and that is instead of reasonable time. And then there's a possibility for an extension as well. So with that being said, any questions on Assembly Bill 23 as detailed in the work session document? Assemblyman Wheeler.
Just a quick comment, Mr. Chair. I did get my second shot, so I will never be on mute again. I wanted you to know that. But I just wanted to thank Dr. Neighbors and the PD for getting together and making sure we've got a bill that absolutely nobody's happy with. It is the perfect bill. Thank you. We will be voting yes.
Thank you, Assemblyman Wheeler. Any other questions about Assembly Bill 23? Okay, I don't see questions, so at this time I'd be looking for a motion to amend and do pass. Assemblywoman Bilbray Axelrod.
I would move to amend and do pass AB 23.
And we had a close one there for a second, but I'll go to Assemblyman Wheeler.
Second the motion, Mr. Chair.
Great, thank you. So we have a motion from Assemblywoman Bilbray Axelrod, a second from Assemblyman Wheeler. Any further comments before we vote? Seeing no further comments, Madam Secretary, could you please call the roll for Assembly Bill 23?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
Yes.
Chairman Yeager.
Yes. It is unanimous of all members present, so the motion does carry. I will assign the floor statement to Assemblywoman Bilbray Axelrod. We'll go next to Assembly Bill 24. Ms. Thornton.
Thank you, Mr. Chair. Assembly Bill 24 was sponsored by this committee on behalf of the Division of Public and Behavioral Health and heard in committee on February 17th. This bill revises the definition of a forensic facility, and there are no amendments to this measure. Thank you.
Thank you, Ms. Thornton. Before we take a motion, any questions about Assembly Bill 24 as detailed on the work session document? Didn't think there'd be questions on that one, but would just have to check anyway. So at this time, I'll be looking for a motion to do pass. Who would like to make that motion? I'll give the motion to Assemblyman O'Neill on that one. So do you want to make that motion, please?
Thank you, Mr. Chair. I make the motion to accept and do pass on AB 24.
Thank you, Assemblyman O'Neill. Who would like to second? I see Vice Chair Wynn. Please go ahead.
I will second that motion.
Thank you. I almost feel like we need to have buzzers at your desk, like it's a game show. Who can press the button faster? Because you kind of have an advantage if I'm looking at you when you raise your hand. But
The jeopardy of the
it would be fun, that's for sure. So, okay, we have a motion on the floor to do pass Assembly Bill 24. Any comments on the motion? Seeing no comments, Madam Secretary, would you please call the roll on Assembly Bill 24?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
yes.
Chairman Yeager.
Yes. So it is unanimous of those present. So the motion does carry. I'll assign that floor statement to Assemblyman O'Neill. We'll go next to Assembly Bill 27. Ms. Thornton.
Thank you, Mr. Chair. Assembly Bill 27 was sponsored by this committee on behalf of the Division of Welfare and Supportive Services. It was heard in committee on February 12th. This bill revises provisions of the Uniform Interstate Family Support Act that governs the issuance of certain orders redirecting child support, and there are no amendments to this measure. Thank you.
Thank you, Ms. Thornton. Any questions on Assembly Bill 27 as detailed in the work session document? I don't see questions. Who would like to make a motion to do pass?
I'll make a motion to do pass Assembly Bill 30? 27.
27.
27.
So Vice Chair Nguyen made the motion to do pass. Let's go to Assemblywoman Kasama for a second. I don't know if we have to say it for the record, but I'll indicate it. Assemblywoman Kasama, second.
Second, sorry.
Thank you. I think I can probably clarify that, but just to be safe, we'll have you say it on the record. So we do have a motion from Vice Chair Nguyen. We have a second from Assemblywoman Kasama. Are there any comments on the motion? And I will note, I think Assemblywoman Gonzalez stepped out for a moment, so she may not be voting. We'll see if she gets back soon enough. Madam Secretary, would you please call the roll on Assembly Bill 27?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Nguyen,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. So that was a unanimous yes vote of all members present. Motion does carry. I'm going to assign the floor statement on Assembly Bill 27 to Assemblywoman Kasama. And with that, we'll go to our next bill on the work session, which is Assembly Bill 30. Ms. Thornton?
Thank you, Mr. Chair. Assembly Bill 30 was sponsored by this committee on behalf of the Division of Child and Family Services and heard in committee on February 11th. This bill revises provisions governing the eligibility for a grant from the account for aid for victims of domestic violence. There's an amendment to the bill sponsored by Ross Armstrong, Administrator, Division of Child and Family Services, and the amendment does the following. First, it revises the name of the account for aid for victims of domestic violence to include sexual violence. It revises provisions to provide that in counties under 100,000, applicants must provide its services primarily rather than exclusively for victims of domestic violence. It revises provisions to include that the applicant must be able to provide counseling for partners of victims and their family members and domestic violence prevention programs for members of the community. And lastly, it revises the procedure for awarding grants in NRS 217.450 to provide that in counties under 100,000, no more than one applicant will be funded. Thank you, Mr. Chair.
Thank you, Ms. Thornton. Any questions from committee members on Assembly Bill 30 as detailed in the work session document? I don't see questions. How about a motion to amend and do pass? Vice Chair?
I will motion to amend and do pass Assembly Bill 30.
Thank you. And I think Assemblywoman Hardy, you want to make the second?
I second the motion.
Thank you. So we have a motion from Vice Chair Nguyen, a second from Assemblywoman Hardy. Any comments before we vote? Okay, I don't see comments. Madam Secretary, would you please do a roll call vote for Assembly Bill 30?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. So all members present did vote yes. The motion carries. I will assign the floor statement for Assembly Bill 30 to Assemblywoman Hardy. And moving right along, I think we're more than halfway done. We'll take up Assembly Bill 37. Ms. Thornton, could you tell us about Assembly Bill 37?
Thank you, Mr. Chair. Assembly Bill 37 was sponsored by this committee on behalf of the Division of Welfare and Supportive Services and heard in committee on February 12th. This bill revises provisions regarding the payment of child support. The bill requires the reporting and withholding of lump sum payments by income payers under certain circumstances. There is one amendment to the bill, sponsored by Steve Fisher, Administrator, Division of Welfare and Supportive Services. The amendment proposes to strike the language in subsections 14 and 15 of Section 5 of the bill. This would remove the reference to workers' compensation reimbursements and insurance settlements included in the definition of lump sum payment. These items are duplicative as they've been addressed in previous legislation. Thank you, Mr. Chair.
Thank you, Ms. Thornton. Committee, you might remember when we discussed this bill, we didn't have the written amendment in front of us, but the sponsor had indicated they wish to strike subsections 14 and 15 because the income payer wouldn't have access to those monies. So what you see in the work session document is just a formalizing of that amendment by the sponsor. And of course, because they're presenting the amendment, it is a friendly amendment. Any questions about Assembly Bill 37 as detailed in the work session document? I don't see questions, so at this time I would take a motion to amend and do pass. Who's going to hit the buzzer first? Vice
I'll
Chair
do
Wynn. Go.
I would move to amend and do pass Assembly Bill 37.
Thank you, Vice Chair. Who would like to second the motion?
So moved.
Was that Assemblywoman Summers Armstrong?
It was.
Okay, thank you. You said it so quickly, your box didn't light up on my screen, so we have a second. So we have a first, we have a motion to amend and do pass from Vice Chair Wynn, a second from Assemblywoman Summers Armstrong. Any comments before we vote? Assemblyman O'Neill.
Thank you, Mr. Chair. I'll be voting to pass this out of committee, but I'd like to reserve the right to change my vote on the floor. I appreciate the amendments that were made. I'd just like a little more time to review the bill. As I said, I'm just asking for that privilege. Please, thank you.
Thank you, Assemblyman O'Neill. I will remind members, this is the first time we've had a work session, but you, of course, as an elected, always have the right to change your vote between committee and the floor. I would just ask as a courtesy if you could let me know if you're going to do that, so that can help me figure out whether we have the votes to move things out or not. But please know that you do always have that right, but appreciate hearing the heads up that there might be some concerns there. Any other comments from committee members on Assembly Bill 37? Okay, I don't see additional comments. So at this time, I'll ask Madam Secretary, could you please do the roll call vote for Assembly Bill 37?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes, and I reserve the right to change my vote on the floor as well.
Assemblywoman Krasner,
Yes, to get it out of committee, but I also reserve my right to change my vote prior to floor vote. Thank you.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes, with reserving my right to change.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
No, and nah, just no.
Chairman Yeager.
Yes. So looks like the vote was 13 yeses, 1 no, 1 absent excuse. The motion does carry. And I'm going to assign the floor statement on Assembly Bill 37 to Assemblyman Orentlicker. And we've got a few more to go, committee. Hang in there. So we're going to take Assembly Bill 107 next. Ms. Thornton, please.
Thank you, Chairman. Assembly Bill 107, sponsored by Assemblyman Yeager and heard in committee on February 19th. This bill revises the procedure for determining whether a person may prosecute or defend a civil action without paying costs. There is an amendment proposed to this by Chair Yeager, and the amendment does the following. First, it includes language referring to an unsworn declaration under the penalty of perjury, provides that the court, based on its review of a person's application, allow the person to commence or defend the action without cost and file or issue any necessary writ, process, pleading, or paper without charge. It deletes language in Section 1, subsection 2A, and replaces it with language that allows the person to submit a statement or otherwise indicate that they are a client of a program for legal aid. It revises Section 1, subsection 2C to clarify that income is referred to as net income. Delete Section 1, subsection 2D, which refers to liquid assets or other assets. And lastly, revises the effective date to 30 days after passage and approval. Thank you, Mr. Chair.
Thank you, Ms. Thornton. Any questions from committee members on Assembly Bill 107 as detailed in the work session document? Assemblywoman Cohen?
Thank you, Chair. And I'm sorry I didn't see this yesterday to ask when we got the work session document. So I believe, as I recall, this is the bill where we discussed that there might have been some concern by practitioners because of a lack of uniformity by the judiciary in making the determination about who is considered indigent, an indigent litigant. And so I just want to make sure that with the conceptual amendment, we're not kind of putting that back in play because of in the new language. Well, I guess that isn't new language. You know what? I don't think that's new language that I'm looking at. So I mean, if you would address that, but actually now looking at it, I think I was looking at the wrong language, and we're not dealing with new language about the court making the determination.
Thank you, Assemblywoman Cohen. And I think you're right. The effort here was to try to have a more standardized process throughout the state. And I think this amendment accomplishes that. I will let members know I've been in some further discussions with members of the judiciary. There could potentially be further amendments to the bill down the line. I don't know that we're 100% there, but I want to get this moving at least through the process. And of course, if it is further amended in some fashion, we'll have a chance to review that or consent to it if it happens over in the Senate. So Assemblywoman Cohen, did that answer your question, hopefully?
Yes, thank you, Chair.
Okay, great, thank you. Are there other questions on Assembly Bill 107 as detailed in the work session document? Okay, don't see further questions, so who would like to make a motion to amend and do pass? Let's go to Assemblyman Miller for that motion.
I make a motion to amend and do pass Assembly Bill 107.
Thank you, Assemblyman Miller, and I think I saw Vice Chair Wynn raise her hand as well.
I will second that.
Great, thank you. So we have a motion from Assemblyman Miller, a second from Vice Chair Wynn. Any comments on the motion before we take the vote? Seeing no comments, Madam Secretary, would you please call the roll for Assembly Bill 107?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. So the motion does carry. It was unanimous yes among those who are present. And since that was my bill, I'll go ahead and take the floor statement for Assembly Bill 107. Just two more to go, committee. We'll go next to Assembly Bill 112. Ms. Thornton?
Thank you, Chair. Assembly Bill 112. Assembly Bill 112 was sponsored by Assembly Members Marzola and Yeager and heard in this committee on February 24th. This bill revises provisions relating to the compromised claims of a minor, and there are no amendments to this measure. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 112 as detailed in the work session document? Assemblyman Wheeler, was that a question? I wasn't sure.
I was going straight for the do pass.
Fantastic. So let me just check. Any other questions? Don't see any other questions. So we do have a do pass from Assemblyman Wheeler. Who would like to second? I see Assemblywoman Bilbray Axelrod. Do you want a second?
Second.
Thank you. Any comments before we vote? Don't see any comments. Madam Secretary, would you please call the roll call vote on Assembly Bill 112?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. The motion does carry. Unanimous of those present. I want to congratulate Assemblywoman Marzola on getting your first bill out of the Assembly Judiciary Committee, and I'm going to assign the floor statement to you so you can tell us about that bill when it reaches the floor.
Thank you, Chair.
So let's take our last bill on the work session, and that is Assembly Bill 140. Ms. Thornton, please tell us about Assembly Bill 140.
Thank you, Chair. Assembly Bill 140 is sponsored by Assembly Members Wynn and Marzola and heard in this committee on February 24th. This bill revises provisions governing the service of process in certain actions or proceedings involving short-term lessors of vehicles. The bill requires a short-term lessor to accept service of the summons and complaint and any other required documents on behalf of a short-term lessee who is not a resident of the United States and who purchased liability insurance for any crash resulting from the operation of the vehicle within this state during the lease. And there are no amendments to this measure. Thank you, Chair.
Thank you, Ms. Thornton. Any questions about Assembly Bill 140 as described in the work session document? Seeing no questions, Vice Chair Wynn, I'm assuming you want to make a motion on this one?
I'd move to do pass Assembly Bill 140.
Thank you. And what Assemblywoman Kasama for the second?
Second.
Great. So we have a motion from Vice Chair Wynn, a second from Assemblywoman Kasama. That motion is a do pass motion. Any comments on the motion? Seeing no comments, Madam Secretary, would you please take the roll call vote on Assembly Bill 140?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. So the motion does carry. It is unanimous of those present. And I want to congratulate Vice Chair Wynn, although this is not her first session in the legislature. This is her first bill of her own to pass out of committee. She joined us a little bit late last session and was not able to request any bills of her own. So congratulations, Vice Chair Wynn. I'm going to give you the floor statement on the bill. And if he's watching, congratulations to Mr. Randall as well on having his first bill co-presented out of the Assembly Judiciary Committee. So committee, I think that's it for the work session document. Thank you for helping us get through that. Just as a way of announcement, because I know we have some new members here, you might be wondering what happens next with these bills. If the bills were due pass and they were not amended, they should be going to the floor very soon, and we will be looking to vote on those in the very near future. For the bills that are amended, legal is going to need to draft those actual formal amendments. They can't just use the ones we submit, so they have to draft their own. And then once those are finished, the bill will be sent to the floor, amended and voted on. So typically the amended bills take a little bit longer to get down to the floor. And hopefully that's helpful in terms of the process. So I'll close the work session on the agenda. And now we'll now go to our last item on the agenda, which is public comment. Just by way of reminder, we reserve up to 30 minutes for public comment. Callers on the public comment line will have up to 2 minutes to provide public comment. BPS, can we go to the phone line to see if we have any public comment this morning?
Thank you, Chair. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. And we will begin caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. Good morning. Today, I'd like to talk about Tashi Brown, who was asphyxiated to death by Las Vegas Metro on May 14th, 2017. Tashi was in the Venetian Hotel and Casino. Tashi believed he was being chased by someone who wanted to hurt him. When he saw 2 LVMPD officers by a coffee shop inside the casino, he ran to them for help, not knowing his nightmare was about to materialize. Rather than providing him with assistance, calming him down, and de-escalating the situation, Kenneth LaPierre began chasing Tashi on foot. Tashi ran through an employee corridor and into the parking garage. When LaPierre caught up with him, who was at a standstill, LaPierre tased Tashi, which caused him to fall down onto the ground and onto his back. In the body cam footage, you can hear LaPierre yelling at him repeatedly to get on his stomach. Tashi, whose both hands were visibly empty and in front of him, kept saying, I will, but the police officer continued to tase him, which made it difficult for Tashi to turn over onto his stomach. As LaPierre continued to tase him, multiple officers arrived at the scene and began forcibly turning Tashi on his stomach, who appeared to be writhing in pain from the taser. LaPierre punched Tashi's head repeatedly and then placed him in an unapproved martial arts chokehold. When a senior officer commanded LaPierre to let him go, he refused and continued to choke Tashi. The body cam video concludes with a view right up Tashi's head as he lay lifeless on the ground. Lapera tased Brown a total of 7 times, punched Tashi over 10 times, and placed him in a chokehold for 1 minute and 13 seconds. I just want to mention the other day when Washoe County presented at the Senate Judiciary, Sergeant Solferino said it's only a matter of time when he talked about the 6 days and deaths at the jail. It's only a matter of time before it happens again. And that physically made me sick. He's right. It's only a matter of time until they acknowledge that prone restraint kills people. Please support bills that promote transparency and accountability. Please do not support bills that protect bad police. Thank you. Have a nice weekend.
Thank you. Thank you for your public comment, Ms. Grant, and have a nice weekend as well. VPS, do we have anybody else on the public comment line?
For any callers wishing to provide public comment, please press *9 now to take your place in the queue. Callers wishing to provide public comment, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers at this time.
Thank you, BPS. I thought we might have Ms. Brown on today, but it doesn't appear we do. So Ms. Brown, if you're listening, we hope you have a great weekend, and I'm sure we'll see you at least or hear from you virtually next week. So with that, I'll close the public comment portion of our agenda. Okay, before we talk about next week, anything else from our very hardworking Assembly Judiciary Committee members this morning? Okay, I don't see anything. I want to thank you all. It felt like it was kind of a long week, even though we didn't have a Monday meeting, and I'm proud that we were able to get some bills moved out to the Assembly floor. I've been watching the Senate, and they are moving bills out as well, so I think we'll start getting some Senate bills, and of course, we're still waiting on a number of our own Assembly bills to be able to hear. So in terms of next week, as I mentioned yesterday, we're not going to have a meeting on Monday, so you get the morning off Monday. And then so far we have 3 agendas out for next week. Tuesday, Wednesday, Thursday are all 8 o'clock starts, and we have bills scheduled for each of those days. We're still waiting to see what's going to happen on Friday. And of course, those agendas for next week can always change as we continue to work on those. So that's the lay of the land for now. I want to thank you all for a great week of Assembly Judiciary Committee meetings. I hope everyone has a really great weekend, and I'm going to see you all back in this committee on Tuesday morning at 8 o'clock. This meeting is adjourned.
Hi, thank you, Chair.
Thank you, Chair.
Thank you. Take care.